And if you like what UUSJ does, if you're connected to UUSJ in several different ways, we encourage you to remember us as we approach the end of the year giving season. As I'm sure most of you know, most nonprofits do the majority of their fundraising throughout the giving season, roughly October, November, December. UUSJ is not unique in that regard. And in our case, we are small and mighty 501c3, and we depend heavily on individual donors and UU congregations. So we'll invite you to remember us in your end of year giving plans. And with that, I turn over the stage to Reverend Latifa out of Florida, one of our cherished and beloved UUSJ trustees and a champion for various issues among our leadership. Reverend Latifa.
Thank you, Pablo. I have a chalice that I'm going to light. I have some words that I'm going to read. But before we begin, let us just take a moment to just breathe away the day, whatever the worries, the issues, whatever you're bringing with you. Let's just leave it where it is so that we may be open. Let's take a few deep breaths. These words are titled, "The Light of Justice." We kindle this light for all who labor unseen, the workers who harvest, package, and prepare the food that sustains us. We light it, too, for those who struggle to feed their families, even while feeding the nation, and for the common table, where everyone is fed and no one goes hungry. May this flame guide our hearts and understanding of policies towards fairness, empathy, and collective care. Amen.
Amen. Thank you so much, Reverend Latifa. So as we continue to let folks into the Zoom, just remember, if you're joining us and you haven't heard me say it already, please put into the chat your name, perhaps your congregation, preferred pronouns, your state, mostly so that our guests have a sense of who's in the room with them. If you happen to have a nondescript identifier on your tile or for your name, like iPhone or Boogie 4 or something like that, please do us a courtesy and change it so that we know who you are. It's an increasing practice among UUs to ask folks to properly identify themselves, even in a Zoom space. Okay. Having said that, I want to introduce our guest speaker tonight. It's our sincere and deep honor and pleasure to have David A. Super, a professor of law at Georgetown Law. David teaches subjects including public welfare law, legislation, administrative law, state and local government law, as well as taxation. Prior to joining Georgetown, he served for 11 years as the general counsel of the very well-known, deeply respected Center on Budget and Policy Priorities, where he specialized in food assistance, immigration, and other public benefit programs for low-income people. At the center, he helped design and win passage of numerous policies to improve the Supplemental Nutrition Assistance Program, SNAP, formerly known as Food Stamps Program. These included categorical eligibility state options to reduce or eliminate limits on the vehicles eligible households may own, simplified reporting, transitional food stamps, longer certification periods, and reforms to the quality control system. Now, that sounded a little wooden. I'm sorry for that, but I do want to say Um, Most importantly, David is one of the foremost experts on SNAP in the United States, and I'm deeply pleased to share with you guys, if you didn't catch it already, he is a Unitarian Universalist. He is a really smart guy. He's committed to the work of bringing equity to the people, of challenging escalating economic inequities. I first met David doing organizing work in Washington, D.C. as part of our UU network. I think it was with the Washington Interfaith Network, David, where we first met. In fact, I think David was part of the crew, the cohort of that moment that recruited me to do some work locally. I know there were others involved, but I distinctly remember David pressing the case that the movement, the organizing needed everybody who could contribute something, and there was definitely a space for me. And it was just a question of figuring out what made the most sense given my talents, capacity, and passion. So with that background, please let's give him our attention in that warm way. Know that he's one of our own. And with that, I give you David Super.
Thank you very, very much, Pablo. And thank you all for taking time out of your evening to come here. I wish I had a happier topic, but that's the world we live in. I do have slides, so I'm going to share my screen. Yeah, I trust people can see that. The question that Pablo asked me to address is whether the SNAP freeze, cutting people off of SNAP benefits in November, is legal. I can give you a short answer to that, no. But I think the idea is that I should explain that a little bit more, and I will do so. I am a lawyer and a law professor, and I do gravitate to the technical. So I have 2 slides of technical, and then I will stop that. There are 2 kinds of entitlement programs in this country, the way we've set things up. One are so-called unappropriated entitlements, where the permanent statute that sets them up not only says who's entitled to benefits, but appropriates the money for that. So it's generally not involved in Annual Appropriations Act. And then there's another kind where the statute gives people an entitlement, but they get appropriations every year from the Appropriations Committee and the Appropriations Act. Social Security is by far the most significant unappropriated entitlement. But when you think about appropriated entitlements, that includes SNAP, but some other pretty heavyweight programs like Medicare, Medicaid, and supplemental security income for the low income elderly and people with disabilities. So being an appropriated entitlement does not mean that there's something minimal or forgotten or whatever about your program. It just means that Congress chooses to oversee it every year through the appropriations process, but the entitlement remains. The entitlement in SNAP can be found in one sentence in Section 5A of the Food and Nutrition Act. Assistance under this program shall be furnished to all eligible individuals who make application for such participation, period, full stop. There's no qualifiers in there. There's not, if the president thinks it's a good idea, if we have appropriations, no. If they're eligible and they apply, then Section 5A gives them an entitlement. And the starting point for all of this is that Section 5A means people should get their benefits, and anything that departs from that is a violation of the law, a violation of Section 5A. The Congress provided a contingency fund. It's done this for the last maybe 15 years. In case there was a breakdown in the appropriations process. We have a lot of government shutdowns these days, and Congress has set aside money. So in 2024, they set aside $3 billion. And in 2025, March of this year, they set aside another $3 billion. So we had a total of $6 billion in the SNAP contingency fund. And just stepping back for a moment, it says it shall be placed in account for use in such amounts as such not as needed to carry out program operations, that program being SNAP. So not a lot of ambiguity as to what you're supposed to use the money for. You can't buy aircraft carriers. You can't build ballrooms. You have to spend it on SNAP. So if you look at just the contingency fund, you can see there's $3 billion in each of the last 2 years was added to it for a total of $6. They spent $475 million administering the program in October. The October benefits were covered by the prior year's appropriation, so that didn't need to be charged to the contingency fund. That left $5.5 billion. The cost of the program in a year is in a month rather is roughly $8.7 billion. That $8 billion for benefits, about 450, give or take, million for administration, and 245 million for a block grant to provide the equivalent of SNAP in Puerto Rico and American Samoa. So you need about 8.7 billion, give or take. So the contingency fund would have supported 2/3 of November SNAP. 2/3 is not 100%, 2/3 is a big cut. But the administration said, oh, we're not going to spend any of it because contingency funds are not available. They're only available to supplement monthly benefits. They're not sufficient to, they're not allowed to cover gaps in appropriation. And you notice the legal citation there? Oh, actually, there is none because there's no legal authority for that at all. I showed you the law a few slides ago. It says for SNAP. It doesn't say for SNAP when there's some appropriation, but not enough. So the administration, after assuring everybody starting September 30th that there would be benefits in November, on October 24th, abruptly changed their position with no legal authority because they thought this was a way to press Democratic senators to cave on the government shutdown fight. They then said the contingency fund can only be used for other things like disaster SNAP. And there's a hurricane, which even as they wrote this, was projected to not make landfall in the continental US and didn't. But they said it's important for us to keep these funds available in case there's a hurricane. Hurricane season is usually winding down by the time you get to November, but okay. And so 42 million people need to go without food assistance so we can take precautions against a possible but unlikely hurricane. And again, the language that provided the contingency fund said to carry out the Food Nutrition Act. They didn't say any one part of it, they said the whole act. Regular benefits are under Section 5A of the Act. Disaster benefits are under Section 5H of the Act, and state administration is under Section 16A of the Act. If you can fund two of those three, which USDA did or said they were ready to do, there's no conceivable legal basis why you can't function the other. There's simply no qualifier anywhere in the Act. These are all operations of SNAP under the Food and Nutrition Act. This is something USDA has recognized for a very long time. When we had a government shutdown in 2013, they sent a letters to states saying there would be limited funds for benefits during that period. Again, in 2015, when it looked like we were going to have a government shutdown, they said contingency funds will provide for some benefits. And you say, oh, that's Obama. Okay, here's Trump. This is the first Trump administration 3 times in January 2019 in what was previously the longest government shutdown in US history, the Trump administration, USDA, said the contingency fund can be used for benefits. So there was never any serious doubt that for including to the Trump administration that the contingency fund could be used for benefits. There was no justification for cutting off benefits and saying the contingency fund couldn't feed that. That was pure politics made up for that purpose. But you say, okay, well, the Obama administration was crazy left wing, and the first Trump administration, that was crazy left wing too. Fine. Here's something from the current Trump administration, September 30th of this year. They said congressional intent is evident that benefits shall be funded in the event a lapse occurs in the middle of a fiscal year. In other words, after the 1st of October, October being paid for by the prior year. So as recently as September 30th, this came down off their website, I think on October 22nd or something like that. So just before they pulled the plug on November SNAP, they were admitting, they had on their own website that the contingency fund was available. This is about as transparently political as possible. And to demonstrate that, I'm going to have to show you something that was on their web page, and I apologize, it is offensive. But this is who they are, and I don't know if you don't want to see something offensive, then turn away, and in 2 slides I'll be past it. But this is what they put up. They took down their plan that said that they could provide benefits, and they put something up there. First, something very partisan, accusing Senate Democrats of being responsible for the government shutdown, ignoring the fact that Republicans rejected the Democratic appropriations bill and Democrats have rejected the Republicans. It's hard to know which is which. And then blaming immigrants and trans people for the problem. This is, if the print was small on that, this is the text of what they said. And it is despicable to blame anyone other than themselves for their completely lawless actions. But they chose to turn SNAP into a political football, and the 42 million people dependent on it likewise. Moving on then, I told you the contingency fund was enough to fund 2/3 of the benefits, but it turns out they can fund the whole thing. They have no shortage because it's a very long-standing section of agriculture law says that they can transfer money that is appropriated from one program in a bureau to another. The Food and Nutrition Service of USDA runs SNAP. It runs several other nutrition programs, the biggest of them being child nutrition and WIC, the Special Supplemental Nutrition Program for Women, Infants, and Children. So if they can find funds in any of those other programs that they could transfer into SNAP, then they could pay the entire November benefit. And as it turns out, the child nutrition program was extremely flush. By the administration's own numbers, it had $30 billion on October 1st. 23 billion of that is a special distribution of customs duties that old agricultural law says that roughly 30%, it's a little more complicated than that, but roughly 30% of what we collect the prior year in customs goes into child nutrition programs, and child nutrition programs receive 2-year appropriations, and there was about 7.3 billion left over from that. So they had a shade over $30 billion on October 1 in child nutrition. Child nutrition programs spend $3 billion a month. So if you do the math, 300 billion for child nutrition, they transferred quite appropriately 300 million of that to WIC to keep WIC running in October. Then spent 3 billion of that on child nutrition in October. One assumes they would spend the same amount on child nutrition in November, and WIC would probably need a $600 million transfer in November. That gets you to $23 billion. The most that you would need to transfer to SNAP to provide full benefits for November was 4.5 billion. So we end up with, if they did the transfer, they would have had $18.5 billion to fund a program that needs 3 billion a year, 6+ months funding for child nutrition. So there's absolutely no threat to child nutrition whatsoever if they transfer the money. Absolutely clear authority to transfer the money. The expenses of miscellaneous expenses for any bureau, division, office shall be available interchangeably for expenses on other objects. This isn't like you have to meet some deep threshold. It just says they're interchangeable. So child nutrition money is available for SNAP, SNAP money is available for WIC, WIC money is available for child nutrition. They can just move it around. There's a 7% limit, but that doesn't apply in extraordinary emergencies, and 42 million people going hungry is pretty obviously an extraordinary emergency. SNAP they'd used this authority to fund, to move money from child nutrition to WIC this year. USDA used this authority to move money from SNAP to WIC in 2023. It's completely routine, or at least it was until this administration came along. But they refused to do that. The administration gave contradictory signs. On November 1st, the president posted on social media that it would be his honor to provide SNAP if a court would just tell him how. But then last week he changed his tune. He attacked the courts. He attacked SNAP. He attacked SNAP recipients. And he said the government should retain liquid, which is a weird way of describing things. But what he meant clearly was withhold SNAP so they would have the money to spend on other things. Never know when you need another ballroom, I guess. So this resulted in litigation, and this is a compressed sequence of what happened. On October 28th and 30th, 2 lawsuits were filed, first by the attorneys general or governors of about half the states and DC. They sued in Massachusetts, and then Democracy Forward sued on behalf of a coalition of nonprofits, cities, Providence, Baltimore, quite a few other cities, nonprofits of various kinds, sued in the federal district court in Rhode Island, both seeking full November SNAP benefits. On October 31st, the Massachusetts court ruled first. They found the SNAP freeze unlawful and told USDA to submit a plan as to what it intended to do by the next Monday, November 3rd. Later that afternoon, the Rhode Island court ordered, rather than demanding a plan, they demanded payment, and they told USDA that it certainly had to use the contingency money. It didn't decide one way or the other about the contingency fund, and told USDA to either pay full SNAP benefits using the transfer authority by Monday, November 3rd, or to pay partial benefits and resolve whatever administrative problems there might be with partial benefits by November 5th. USDA on November 4th said it would only issue partial SNAP and put out a plan for how benefits would be cut to use the full amount of the contingency fund. However, that plan was completely wrong. It cut benefits way deeper than the contingency fund. I don't like to speculate about people's motives, so I have no idea whether they bumbled this or whether they deliberately lowballed it to avoid giving people any more SNAP than they thought they could get away with. But whatever the case may be, it's really a very easy calculation. I did it, and I'm a lawyer. And some serious people at the Center on Budget who actually are very good at this did it, and we both came to the same conclusion that USDA had cut way deeper than it needed to. This people at the Center on Budget wrote up their results. Plaintiffs filed it as a with the court to show that USDA had miscalculated, and later that day USDA admits, well, yes, I guess we did. Yes, you did. Very, very straightforward. So this recalculating benefits is a lot of work for states. Some states have that well automated, but a bunch of states don't. So all the work states started doing on November 4th, they had to scrap and start over again based on the new tables that USDA admitted after they were called out on November 5th. So if you're seeing a pattern here of things moving slowly, you are paying good attention. On November 6th, Thursday, the Rhode Island court issued two orders. Number one, it said that USDA had violated its prior order, which required SNAP, if they were going to do partial SNAP, for them to pay by Wednesday. They didn't. And it resolved the transfer authority issue and said that USDA did indeed have to use the transfer authority. And the basis of that is very simple. There's a clear entitlement, and USDA can't say they don't have the funds because they have the transfer authority. So they do have access to the funds. The funds are supposed to be used interchangeably. So that's Thursday afternoon. The court orders USDA to pay full benefits by Friday, the next day. That afternoon, the next afternoon, Friday, November 7th, USDA sends out a memo to the state saying, we're working towards full issuance. We'll have that done in a few hours. It says nothing about that this is contingent on the court order not being overturned. It just says we're moving. Late that night, Justice Jackson of the Supreme Court issued a short-term stay of the Rhode Island court's order for a few days. But in response to the Rhode Island court order and USDA's memo saying move to full benefits, a bunch of states issued full benefits. They obviously understood people were going without, and they had been ready to issue full benefits since late October, so they just went and did it. A lot of these are blue states, but some of them are red states. People understand that families can't wait for their SNAP. So a lot of states put that out the door. Then Saturday evening, November 8th, more than basically a day after Justice Jackson issued her stay, and well over a day after USDA put out the memo saying give everybody full benefits, they then put out a very nasty memo saying that states had no business issuing benefits and they had to undo their action or they would face very severe punishment, which is a very curious way of dealing with states, remarkably disrespectful. The states then asked the Massachusetts court for an injunction against USDA carrying out any of these threats, which was granted. As Justice Jackson's stay was about to expire on November 11th, the full Supreme Court extended that 2 more days, I think, to avoid dealing with the issue because they saw that the government shutdown was ending. So the end result of this is there may be some further litigation about whether USDA can punish states for doing the right thing by their people. And again, a lot of blue states, but some red states like North Dakota all did the right thing based on USDA's memo. And there's a class action filed by a group of recipients, of SNAP recipients in California, that are seeking a permanent order that this is not how things are supposed to go in government shutdowns. An entitlement is an entitlement. I don't know if the court will consider that or will regard this as moot, but that's where the legality sort of wound up. There's some things to learn from this episode. Obviously, the willingness to use 42 million hungry Americans to play politics and generate leverage on your political opponents is deeply disturbing, at least to me. But this is also part of a broader executive power grab. And just to contrast, the Constitution says that Congress appropriates money. But the government's brief signed by the Solicitor General, so this is not some random Justice Department lawyer, but it is the top lawyer for in front of the Supreme Court, said that federal court should not interfere with the executive as it exercises its authority of appropriating limited funds. All of a sudden, the appropriations power has moved from Congress to the president. This is consistent with a lot of other moves to strip Congress of the power of the purse that we've been seeing over the last 9 or so months. And I think the SNAP freeze can be seen as a big part of that. Again, the source of limiting the president's authority is the entitlement. And the president never came up with an explanation for why he was entitled to violate this law, requiring him to furnish SNAP to everyone who was eligible and applied. So a lot of harm has been done. A lot of people use their rent and utility money to buy food of necessity. You cannot pay rent or utilities with SNAP benefits. There are severe penalties if you sell SNAP benefits or use them for anything but food. And so we're going to see rounds of utility terminations and evictions and other crises. Households that are dependent on SNAP and have their SNAP cut off sometimes hand their children over to the custody of other relatives who have more food and sometimes have trouble getting them back. So the range and depth of the disruptions in the low-income community that is coming out of this is pretty staggering and pretty disturbing. Given such a clear entitlement is hard to understand. In addition, many SNAP households' troubles are not over. They are in some sense going out of the frying pan of the government shutdown and into the severe cuts to SNAP that the One Big Beautiful Bill Act imposed last summer. It'd be a longer talk to go through all of those and what they mean. But I want to talk about one briefly that's taking effect in many states in November. So many households will get late November, their November benefits late, and then will get kicked off for November indefinitely. And that is the so-called work requirement, which is not really a work requirement at all. Traditional work requirements said if you choose to work, you get benefits. If you refuse to work, then we take your benefits away. There's a lot of problems with that. There's a lot of circumstances where that's counterproductive. Those programs have been found not to increase employability or employment or hours or earnings or anything that we would care about other than sanctions and hardship. But at least that is premised on a choice, giving people a chance to work and seeing how they respond to that. But that's not what One Big Beautiful Bill Act or what SNAP are doing now. They're basically saying that someone who can't find a job or can't find a job for 20 hours a week or can't find a job for 20 hours a week that is willing to submit paperwork, in other words, that is not hiring them off the books, that they are ineligible simply because they're not working, even if they're trying as hard as they can to find employment. And that is going to affect a lot of people. Since the 1996 welfare law, this has been the policy for childless adults age 18 to 49. This law added that for people ages 50 to 64. That means that people who are on early retirement under Social Security, our nation's primary retirement policy, says, yes, if you'll take reduced benefits, you can retire at 62. SNAP says, no, you can't. If you aren't working 20 hours a week, no SNAP for you. We also, in One Big Beautiful Bill Act, extended it to parents of children age 14 and up, not the children themselves, but their parents. And obviously, if you cut off SNAP for the parents, then there's going to be a lot less food on the table that all the members of the family are eating from. In addition, the One Big Beautiful Bill Act eliminated provisions or effectively eliminated provisions of prior law that had exempted areas with high unemployment. So there are important areas around the country, Philadelphia, Washington, D.C., Chicago, to name three large ones, and many smaller areas that have literally never been subject to this penalty on unemployment because there's enough problems getting jobs there. And under One Big Beautiful Bill Act, the inability to find work is no longer a justification for being out from under this. People have to have 20 hours a week of work in order to get SNAP, no matter how hard they're trying to find it, unless they meet some relatively narrow exemption criteria. This is something that UUs may want to think about because volunteer work does count towards this test. And there are a lot of ways in which one can do it. In other words, it doesn't have to be paid. I would love to see UU churches and others set up places where people can come and sign in as volunteers. And if there's work for them to be doing, obviously they do it. If there isn't, they can wait until work is there, but be clocked in. And if there's a place where people can come for 20 hours a week that is labeled a volunteer opportunity, then those people can get SNAP. A lot of folks, frankly, on SNAP are busy trying to get a job to get off of SNAP. But some of them are frustrated and would welcome the chance to be able to do something to continue SNAP until their employment prospects improve. So with that, I would be eager to take any questions.
Thank you so much, David. What a enlightening presentation. And I think it was even better than the first time I caught it. So thank you.
Thank you.
More graphics, more accessible. So I want to invite folks, David's presentation was rather weighty because this is a weighty topic and it's steeped in the legal maneuvering that's available to an administration that wants to do all the maneuvering possible. So, you may have questions on your mind, and I want to invite you to raise your electronic hand if possible. That's available to you as part of your dialog box, usually under the React icon, and then I will recognize you. But as you're summoning your courage, I'll just ask a question, David, which is, clearly the shutdown is over. Clearly you've enumerated at least the one change for OVBA that people should expect. But when you take a step back from the maneuvering around the shutdown, can you name for us one or two consequences in terms of precedent that we should all be watching out for? You think there's a systemic risk here that's emerging from the back and forth on SNAP that is important for us to take special note of?
I think there is. I can't prove what I'm about to say, but I strongly suspect it. Everybody, all of the judges that were seriously involved in this case, the two district judges in Rhode Island and Massachusetts, and I sort of skipped over this, but there was also the case went briefly to the First Circuit Court of Appeals in Boston. All of them operated on the assumption that the Supreme Court would be extremely reluctant to force the government to pay benefits, even though the legal case, which I've explained here, is really straightforward. The entitlement is short, sweet, unambiguous, and yet no one really believed that the Supreme Court would do it. They were bending themselves into pretzels to find a way of avoiding forcing the Supreme Court to decide. The reason for that is that there are three justices who clearly would have been willing to enforce this, Justices Jackson, Sotomayor, and Kagan. The Chief Justice on clear cases like this has been willing to slap down the administration. But to get a fifth vote, you pretty much have to go to Justice Barrett. There's really no other option. And she has said repeatedly that the government shouldn't be required to spend money until a lawsuit is completely resolved, because they'd never be able to get the money back if they won the case. This is a case the government was never going to win. Their legal arguments were absurd, were contradicted by things they themselves had said a few weeks earlier and in the prior Trump administration. But none of the judges believed that even in a case where the harm of not spending the money was massive for 42 million Americans, and where the legal argument for the government was trivial, people still didn't think the court would do that. That they didn't think Justice Barrett would do that. I hope they were too pessimistic, but we're operating in a setting where people, including judges, don't expect the Supreme Court to enforce the law, and that's scary.
Indeed. It's sort of not, I mean, I'm not a legal expert, but it sort of sets up a new gray space legally, a new gray docket, where judges are trying to guess which cases will actually be taken seriously and acted upon. And based on your description just now, it means, gee whiz, any case that's brought by a plaintiff and reaches the Supreme Court, you may have to wait till the full end to see the government act and hold people harmless in their damages. That's pretty severe from my very basic understanding.
And cases
Okay.
to take fully resolved through the appeals, that's 2 years minimum, even if everybody is stepping on it. And SNAP benefits 2 years late. I mean, I guess better than no SNAP benefits at all, but you can't run a program like that. You can't meet people's needs like that. So that is effectively saying that the power of the purse has indeed migrated from Congress to the president, and they can refuse to spend money for the most absurd reasons and get away with it.
Wow. Thank you for flagging that for us. I'm going to invite Lisa to come off of mic. She said, it seems Lisa was
Hi.
going to ask a question. Okay.
Thank
go
you
for it,
so
Lisa.
much. It's been very informative. The exceptions for the work rule, does that include disability?
It does. In a less than lovely turn of phrase, the act says that if you're unfit for work, then you are exempted. There are no formal requirements for how that's proven. The regulations say that if it is obvious that an eligibility worker can grant that, which back in the day of bricks and mortar welfare offices meant something. Now with it being electronic and remote in so many states, it's, I think, going to be challenging for people, even if they have disabilities, long-term or short-term, to get the paperwork to prove that they have that. And obviously in a lot of areas, they may not have healthcare coverage. And that can make it even harder to get any documentation of disability. But yes, if you can one way or another persuade them that you are unfit for employment, then you are exempt. Yes.
Thank you.
I want to encourage folks to raise their electronic hand, or you can try to get my attention with your flesh and bone hand. Maybe I'll see you, maybe I won't. I guess I'll ask another one, David. It's quite possible, not guaranteed, but it's quite possible that we'll be in some version of a shutdown in January again. So, what are the food-related liabilities in that potential interaction? What do you think people should know about that?
Fortunately, SNAP will not be invited to that party if we have one. The continuing resolution that ended the shutdown included year-long funding for veterans programs and ag programs, including all the nutrition programs. So there will be no funding crisis until October at the earliest for SNAP, child nutrition, or WIC. There is potential difficulty in HHS, which does run some food-related programs, particularly for seniors, that could get bound up in a crisis if we have one at the end of January. But all the big food programs are secure until October.
Well, thank you for confirming what I thought I knew, but it's always good to hear it from an expert like you. Any other questions? If not, going once, going twice. Well, then I'm going to thank David for his time. And if Reverend Latifa is still with us, I'm going to invite Reverend Latifa to give us a short prayer in closing.
Yes, I will. Thank you, David. Your presentation was very informative, and I love the visuals. I was taking photos, so thank you. All right. From light to action. As this flame fades, may its glow travel with us into the halls of power, the aisles of grocery stores, and the spaces where policies become people's lives. And may justice never be an afterthought, but the first ingredient in every plan we make. Go in peace, friends. Amen.